co-counsel is ill and not able to appear today.
Yes, I heard that. Please tell her I wish her a speedy recovery.
I will, Your Honor. Thank you.
All right, good morning. You can be seated. The court is aware that the prosecution filed a motion entitled Joint Representation Safeguards, and that motion is set for tomorrow. However, prior to receiving that motion, the court discussed this important issue sua sponte. The court is cognizant of the defendant's Sixth Amendment rights to retain counsel of their choice. But the court is also obligated and committed to preserving a defendant's right to a zealous defense. Michigan Rule of Professional Conduct 1.72b indicates that a lawyer shall not represent a client if the representation of that client may be materially limited by the lawyer's responsibilities to another client or to a third person. Michigan Court Rule 6.005 states that whenever two or more defendants who have been jointly charged or whose cases have been joined are represented by the same retained lawyers or lawyers associated in the practice of law, the court must inquire into the potential for a conflict of interest that might jeopardize the right of each defendant to the undivided loyalty of the lawyer. The court may not permit the joint representation unless, 1, the lawyer or lawyers state on the record the reasons for believing that joint representation in all probability will not cause a conflict of interest. 2, the defendants state on the record after the court's inquiry and the lawyer's statement that they desire to proceed with the same lawyer. And the court finds on the record that joint representation in all probability will not cause a conflict of interest and states its reasons for the finding. Joint representation of co-defendants charged in criminal matters by attorneys from the same law firm is uncommon. There is great concern that there may be a conflict of interest as incompatibility of positions may arise at any moment. Of additional concern, Michigan Rule of Professional Conduct 3.7 states that a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. I don't yet know if that rule is implicated, but I want to be clear that a lawyer providing representation in this matter will not be permitted to also testify. These concerns need to be addressed both in the short term and in the long term in the event that these matters go to jury trial. To this end, the court is appointing independent counsel for each defendant. The appointment of counsel will not be as a substitute for the defendant's current counsel of choice or to report back to this court. The purpose of independent counsel will be for the limited purpose of advising each defendant in the matter with regard to joint representation and the potential for conflicts of interest. The court is aware that a defendant is permitted to make a knowing and voluntary waiver of his or her right to conflict-free counsel. I will be inquiring each defendant at our next pretrial if they intend to waive any potential conflict. I will also be asking for a written waiver by each defendant. If it appears that a written waiver becomes necessary, substituting with independent counsel, I'm requesting the prosecution and defendants agree to language and present a proposed written waiver. In the meantime, I'm going to take this motion for presentation safeguard, which is set for tomorrow under advice. I don't instead respond. I'm also going to set another I want to ask if you are on April 5th at 10 a.m. I keep in mind that easy in the to set a you probably in my courtroom. There's a murder trial courtroom, just set things without asking. So,
does the date work for the people?
Your Honor, I do see that Ms. Smith has a trial that day in another county. I can speak with her if you'd like to schedule it. I can speak with her regarding that trial.
Okay, are difficulties that we didn't have in the past, moving things around. Obviously, this case is of great interest to a great number of people, so there's a lot of people to notify for a pretrial or any kind of proceeding. The other thing is that I don't sort of hold out. I have a room, you know, so that's jury free. So if for some reason you can't make that, you need to know in a timely way because it's more trouble than it used to be. So,
Everyone today.
and if you could get back to my staff, we could wait. I think I'm going to be next Tuesday. That would, and I don't have a courtroom, so.
Judge, just one question regarding the written waiver form. The people did attach as an exhibit a proposed waiver form. In counsel's response, I didn't see a specific objection. Counsel, do you have an objection to the language in the form attached?
I would prefer that we discuss this off the record and maybe confer and decide whether or not we approve of the language that's included in the waiver.
I don't think I've seen that because I don't know if I have that attachment. It probably was filed. But I guess I'd like it if you confer on that. I hope the Crumleys understand the purpose for the independent counsel. I'm concerned that at some point today, tomorrow, next week, a month from now, 4 months from now, that something could happen to cause a conflict that could damage your position, Mr. Crumbley, or your position, Mrs. Crumbley. And I have an obligation to protect your rights, and I'm concerned, as we sit here right now, that there could be a myriad of things that are incompatible. So I'm sending appointed counsel, independent counsel, and their job isn't to report back to me. Their job isn't to take the place of your attorney. They're going to talk to you about a conflict of interest, potential conflict of interest, and what would be in your best interest. So I would urge you to listen to them and ask them any questions you might have. Because obviously this is very stressful for everyone involved. I'm trying to avoid your rights being implicated in a negative way, but I'm also trying to avoid having to recreate or go backwards with regard to this case. For example, if the matter is in trial and there's a conflict in the middle of a trial, that could cause a mistrial. I'm sure it's no surprise to you that the court is very backed up. I happen to have a fairly reasonable docket, but some of the judges in the courthouse are trying cases where individuals have been in jail 700 days. And that would not be my intent if your matter goes to trial. I would give you the speediest trial possible. However, if there's a mistrial because of some conflict that arises during a trial, we'd be back at square one. So I want to avoid all of that. All right. So you should be visited within the next 2 weeks, and they'll talk to you about these issues. Your lawyers might also have positions with regard to this. You know, now there's the preliminary examination, transcript is available, and discovery, and that could make a difference in what you choose going forward. All right. Anything else?
Judge, just procedurally so we understand, the court will appoint independent counsel. Counsel will meet with the Crumleys separately.
Separately, 2 separate lawyers.
Okay, 2 separate lawyers, and that is in the presence only of the independent attorney with the defendant. Am I correct?
Absolutely. Okay. Absolutely. The independent lawyer will be there with Mrs. Crumbley, and a separate independent lawyer will be with Mr. Crumbley. Absolutely.
Thank you, Judge. And I'll work with opposing counsel. We'll put together a form and send it to the court.
I'd appreciate that. If at the next court date, I'll be wanting to move forward, and I'll be asking both sides what kind of motions they might have to file. Okay. Anything else?
For the people. Thank you, Judge.
Nothing from the defense, Your Honor.
All right.
So we assume because you disposed of the other motion that.
Correct.
Okay.
That's correct. I hope Ms. Smith feels better.
Thank you, Your Honor. I appreciate that.
All right. Thank you.
All right.
Okay, so we have our form.
We'll talk to you about it, yeah. No, not right now. We'll talk about it.
Or you need the car for feeding. Oh, that's fine. So you need the car? Yeah, that's great. I mean, you guys are all set, all right? Thank you. So you'll let us know when that date comes up today? Correct. Okay. Hopefully they're gonna make that April 10th, April 5th date work. Okay. Otherwise, no, it's talking all you out. Thank you. Thank you. Nice meeting you too.
Hey, how you doing, Paul?